century doesn't matter. What does matter is how Congress chooses to organize it. Today, of course, it's organized as the National Guard system. Now, one of the other rights that, or powers that the Constitution had given to the national government was the right not only to organize the militia, but to arm the militia, also to provide discipline for the militia. During the ratification debates, when the anti-federalists were arguing against ratifying the Constitution, one of the most dramatic events during this episode took place in Richmond, Virginia in 1788. It was the ratifying convention in Virginia, incredibly dramatic. It looked at that point as if Virginia did not ratify, there would not be the necessary 9 states to ratify, and the United States would not come into being. And on one side were the brain of the Anti-Federalists, George Mason, and the most eloquent member of the Anti-Federalists, Patrick Henry. And on the other side, for the Federalists, was basically the man who wrote the Constitution, James Madison. Very dramatic. And the Anti-Federalists raised many, many arguments against ratification, but one of them that Mason and Patrick Henry launched was they basically said to Madison, this was in Virginia, this was in Richmond, Virginia, Eastern Virginia. Majority population in Eastern Virginia was in the enslaved black population. John Peyton's absolutely right. The white population lived in perpetual fear of slave revolts. And what Mason and particularly Patrick Henry basically said to Madison was they said, James, in Philadelphia, you deprived the federal government of the power to abolish slavery. That was part of the slave compromise. Very good. But you have given the national government a mechanism to undermine the slave system indirectly. When you gave Congress the power to arm the militia, that's exclusive. That means only Congress can arm the militia. And the eastern states, that's what they call the northern states, but I'll call them the northern states from now on, they're already abolitionists. They already hate the slave system. And now you've given them the power to disarm our militia. And our militia is our slave control mechanism. In fact, it was so important to the South that there were exceptions, but in the main, the South refused to commit her militia to the war against the British for fear of slave revolts. And Madison said, oh no, listen, that power is concurrent. If Congress doesn't arm the militia, then the states can arm the militia. And normally, Patrick Henry was no match for James Madison on substantive matters, but this was late in the day and Madison was tired, and Patrick Henry was a brilliant polemicist, and he ridiculed Madison quite effectively. He said, oh really? So the power is concurrent. So when you say that, when in the Constitution you say that Congress has the power to arm the militia, that means it's concurrent. Congress could do it, the states can do it. And when you say that we, the states, have the power to appoint the officers of the militia, I suppose that's concurrent. So we could appoint the officers or Congress could. And he went on and on about this. Clearly it was a pretty effective attack on Madison, saying when these authorities had been doled out, some to the federal government, some to the states, they were concurrent. So it's a long story, but I'm going to cut to the chase here. When the following year Madison went off to the House of Representatives after the Anti-Federalists had deprived him of a seat in the Senate and attempted to extinguish his political career by getting James Monroe, rising star of the Anti-Federalists, to run against him in the House and gerrymandering his district, and arguing to the gerrymandered district Madison's been against the Bill of Rights, been against the Bill of Rights. That was the principal argument. And Madison changed his view during the election and said, well, I was against the Bill of Rights before ratification. Now that it's been ratified, I'm in favor of the Bill of Rights. And he went off to Congress. I believe that when he wrote the Second Amendment, he attempted basically to fix the problem that Henry and George Mason had accused him of creating in the Constitution. A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. Now Madison was intent that nothing in the amendments would contradict anything in the main body of the Constitution. So he wasn't going to amend Article 1, Section 8 and say that this was concurrent. But the essence of it was that if the federal government doesn't provide arms to the militia, then the states could do it, or the people could themselves, and in fact, that's how the states were arming their militias at the time. They simply passed laws that said militia members shall come with their own musket. And that musket was not treated as an item of private property. There were also lots of laws about that musket. You couldn't encumber it. They handed over as collateral for a debt and many other things because it was a militia weapon. So I suggest to you that that is really what they were thinking about. When you walked in here, and if I said, close your eyes and think of an image that goes with the right to bear arms, many of you would have closed your eyes and pictured the Minutemen at Lexington and Concord with the musket in their hands. But I suggest to you that because the realities of the day, what they were really thinking about, particularly Madison and the southern states and the southern members of Congress, was the musket in the hands of the slave owners.
Thank you, Carl. I want to leave time for questions, but I have a couple of the panel, and you may want to respond to each other a little bit. But this is